Good afternoon, everybody. Thank you for joining us. I'm Katie Sabota-Kindle from Community Legal Services, and we're very happy to be putting on this webinar today, FCRA 101, what every legal aid lawyer needs to know, as part of our National Record Clearing Project through the support of the W.K. Kellogg Foundation. So we are so lucky today to be taught basics by true experts, like we're being taught how to dribble by Michael Jordan or something. So we have here today Jim Francis and Lauren Brennan. They're both from Francis Mailman and Soumilas, which is one of the premier consumer rights firms in the country. It's a firm that's dedicated to doing this sorts of work, including litigation under the Fair Credit Reporting Act, which is what we're going to be talking about today. So we have Jim Francis. He was a co-founder of the firm in 1998, and he's been at the forefront of some of the most important litigation since that time. So including Ramirez versus TransUnion, which is a recent case where it had a record-breaking verdict, $60 million for the class. Also Cortez versus TransUnion, which was a seminal FCRA case. And he's been appointed as class counsel for over 60 cases all over the country. So a true expert and one of the leading litigators in this field. We also have Lauren Brennan, who's been at the same firm since 2013, and her practice concentrates on the stuff we're talking about today, which is litigation on behalf of consumers who've been harmed by bad credit reporting errors, inaccurate employment background screens. So these two attorneys are truly overqualified for being here and teaching us about the basics. We're so lucky to have them. Just before we get started, I want to do a couple housekeeping things. First of all, this webinar is being recorded. It will be made available later, and we'll send it out to you. Our presenters would like to handle questions as they come. If you have questions, please put them into the chat. You'll see a little box should appear that says chat. Please put your questions in there, and they will try to answer that as they go. And then we'll try to leave some time at the end also for questions. So if you have questions, please just go ahead and put them in the chat, and we'll address them as soon as we can. We will also, there's a few handouts. So there's 3 materials that are in the handout section, which our presenters might refer to today. I also sent those in an email right before we started, so that everyone should have those in both ways. We'll also send those out again after the webinar is over. So without further ado, if we can turn it over to Jim and Lauren.
Thank you, Katie. Sorry, we're starting 2 minutes late. We had a little bit of a technical issue, but we're back on. Hopefully everybody can see us and hear us. If we were live, I would say raise your hands if you can't hear us, but I can't. So hopefully you can hear and see us. So we're going to try to give you a really brief and quick summary of the FCRA in general. It's a pretty broad statute, but has a lot of applicability to a lot of different, consumer issues and fields of law, and really spans a lot of, I think, different dimensions of consumer work. And I think for legal aid lawyers, and I think there are a couple of areas that are a particular concern. One is in the expungement arena. For those of you who assist with getting expungements on behalf of your clients, the FCRA has broad and significant applicability for when you get an expungement, and then for whatever reason that expungement doesn't work its way into the Consumer Reporting Agency's record of that record. I think that's something we're going to focus on today, and it's very germane to your practice. Also, within that same context, the FCRA, unlike what a lot of people think, applies to employment. And to the extent that your clients are trying to get jobs and they're not able to get jobs because of the background check, the FCRA is right there as well, acts as a protection for your client. And helps you because it has fee shifting, and it provides the client with some tools. So those are the 2 main areas: the expungement of public records or criminal records, and employment that we're going to focus on. But Lauren, do you think those are the 2 main areas that are applicable or most important for legal aid?
Yeah, the other thing that I would point out is that tenant screening is going to be another place where consumer reporting is really going to affect, tenant screening is going to really be a place where consumer reporting law can help your clients, especially people who have a criminal history in their background, or where criminal history is really going to affect people's lives. So employment and tenant screening are the two places. So we're going to talk about how the FCRA works, and differently or the same between tenant screening and employment screening, as Jim talked about.
Yeah, and I'll just add, just by way of full disclosure here, the disclosure that we're proud of. We've had a lot of work with your colleagues, some of you probably watching right now. We've co-counseled cases, class action cases, individual cases with CLS, with other legal aid organizations, Mid-Penn Legal Services, the New York Legal Action Center. And to me, it's been one of the most gratifying, parts of my practice is working with other legal aid lawyers on FCRA issues to get relief for clients. Because as I said, the statute really does provide some good tools for the clients that you're facing every day. So we'd love the opportunity to answer any questions you have next week, next month, a year from now. We'll always make ourselves available, and we'd love to co-counsel cases with any of you, or just assist you with your client's needs. So why don't we just, Lauren,
so there's already a question in the chat, Jim, that I think is a good introductory point. What if my clients have no money, no credit, and even if they had credit, would not be likely to get a loan anyway? Are they still good plaintiffs for FCRA cases?
You want to start with that?
What do you think about that?
I mean, I think the answer to that question is they can be. The FCRA has mandatory fee shifting, and it has a lot of procedural and technical requirements. So sometimes, even if your candidate or your client does not have what you consider to be a great case, there might be methods by which the fee shifting could occur that would allow a private litigator like our firm to get involved. Or if it's a systemic problem, it's something that could be handled on a class basis, that also might provide an opportunity for that client's interest. So the answer is, I would say, likely, not a guarantee, but I'd say explore it, give it a shot.
Yeah, if there is inaccurate information that's making someone's credit or background look worse than it is, the causation standard under the Fair Credit Reporting Act is just that it could be one of many causes, and you can still recover under the FCRA. So certainly we represent plenty of people that do not have perfect pasts, and that's
we had a case years ago. I remember it was called King versus GIS. It was a case that we co-counseled with CLS, and it was brought against one of the background screeners, one of the largest ones at the time, General Information Services, and we had a client that did have a criminal record. But it was a misdemeanor, but there were 9 charges associated with that particular misdemeanor that had aged off of her report, meaning under the FCRA, after 7 years, all adverse action, other than a bankruptcy, has to age off. And they were still reporting these 9 charges. So even though the person had a misdemeanor, which resulted in a conviction, which can be reported beyond 7 years, there were also like 10 pages of charges that predated that 7-year period. And that was a really good case because it represented them and portrayed that client as having a much more significant criminal record than she did. In that case, Lauren, I think we worked on that case together. I think we got a settlement in that case, about $3.5 million against GIS. So you never know with the FCRA, it's always worth exploring. So
right, and maybe even more importantly, we got them to change their practices for not including those other older offenses, even when they were tied to a conviction offense. So that's what we like doing, is not just getting money for our clients, but getting the practices changed through class actions. Yeah, let's get into some of the specifics here. Can we move to the next slide? So we call it the Fair Credit Reporting Act. You'll hear it FCRA. Most plaintiffs lawyers that I hear call it the FCRA, but people will know what you mean. It's a little bit weird though, because it's called the Fair Credit Reporting Act. That's the title of it. But it actually it's not limited to credit reporting. It's about consumer information and consumer reporting. So when you say CRA, it's actually not credit reporting agency, it's consumer reporting agency. And that's why, as Jim said, it's an incredibly broad statute that applies in a lot more situations than just credit data. And that's why we're talking about it in the context of tenant screening and employment background checks and reports that may not have any credit data on them at all. So the next slide gives you the definition of what a consumer report is, and you can see in the bold portion that it can include any report that bears on an individual's character, their genuine reputation, their personal characteristics, their mode of living. I mean, there's a lot of arguments, especially with aggregation of big data, that all different kinds of reports, knowing somebody's zip code can tell you a lot about them. And people can glean a lot of information about the zip code where somebody lives. So I think there's a reasonable argument that even saying this person lives in this zip code could potentially be a consumer report under the law.
Yeah, and let me just stop you there, Lauren. Can we go back to the last slide?
Yeah.
Just look how broad this definition is. Again, people think of credit reports, and that's just one tiny portion of information that this statute regulates. But a criminal record sold to an employer is a consumer report. It reflects upon their general reputation, their character, or any other aspect of them and their eligibility for getting employment. So that's a really, really strong one, and there's a whole area of FCRA litigation that just relates to criminal records sold to employers. But as Lauren said, more and more landlords are using them to either look at eviction history or credit history, as well as criminal records in terms of determining whether or not to extend a lease or in connection with a tenant screening situation. Car insurance is another example. Laura and I had a case involving life insurance where medical information is being used and sold, prescription history and medical history is being sold in connection with life insurance applications. There are so many different applicabilities of the FCRA. So if we can go to the next slide. Right, so there's two terms of art in the statute. One is a consumer report and one is a consumer file. And I think the simplest way to describe it is when information is sold to a third party, such as an employer or a creditor or a landlord, that's a consumer report. When a consumer asks the reporting agency for a copy of his or her file directly, that's what's considered to be a consumer file, and that is subject to different requirements than the credit report, than what a credit report is.
And we can get into, we have consumer disclosure is a smaller part of the consumer file, and where that's going to come in practical application, especially in the when we're dealing in the legal aid context, is how are you going to talk about what you're asking for when you make a request for information? And we'll have a further slide on that. But it's worth understanding that you may need to tailor your request in a particular way to make sure you're getting the information you really need. So the next slide is just giving you some names to look out for of who the major players are. Most people, I think, recognize the names Experian, TransUnion, Equifax, and those are going to be where the credit data is coming from. Oftentimes in the tenant screening and employment screening space, you may have both credit data and criminal records or other public record data on the same report. And so oftentimes that credit data is being purchased from an Experian, for example, by, just use the tenant screening example, RentGrow. So there'll be a section on the report that has the credit data from Experian, and then a section of the report with other types of information that RentGrow purportedly goes out and gets itself. And again, they tend to be relatively specific to the industry. So, there are CRAs that specialize in tenant screening, and there are CRAs that specialize in employment screening. And as Jim was saying, medical information, check services is another one where you may see people with lesser means having problems because they're getting denied a checking account because they had, they're having some sort of information being reported when they go to try to open a new checking account. The previous bad banking history might come and bite them and push them out of the traditional banking system. And so you see that with banking and check services.
And while we're on this slide really quickly, let me just point out, I'm going to try to weave in how to handle a client as we go through some of these. So these are the major players. But as Lauren and I were talking about just a few minutes ago with regard to the consumer file, one of the things that's very important to know is every consumer is entitled to a free report or disclosure from any CRA once a year. So the first thing you want to do when you have a client walk in with a problem is make sure you get a formal disclosure from one of these companies that's actually selling the data. Sometimes your client will walk in with either one page of the report that was given to them. Sometimes the employer or the landlord that denied them doesn't give them a copy of the report. In fact, usually that's the case. So it's important that as long as you know who the entity is, you on behalf of your client make a request for a free file disclosure. Then you have everything now to begin with to see what's incorrect, what needs to be disputed. That's another provision that's very, very important for you as a practitioner and as representing your clients, is that I can get the information being sold about them, and they have a right to dispute it, and it's all free, and the agencies have to provide both of those items, the report as well as a full investigation. And let's go to the next slide. All right, Lauren, why don't you take it away here?
Yeah, so I think one of the big misunderstandings is often where this data comes from, and that's partially because these companies try to hide it, right? Like I said, if you're particularly in the tenant screening space, a little bit in employment screening, depending on the type of job you're looking at, there's credit data and other types of data. And so, as I said, the credit data comes from the big three. That's usually pretty clear on the face of the report. But often these CRAs and background screeners in particular like to make it seem like they're getting these records directly from courthouses. They'll say source of the record is, the Philadelphia Court of Common Pleas. That is almost never the case. So data scrapers would be companies that pull publicly available information off the internet to the extent it's not behind some sort of password or paywall. But the major source of public record information when you're talking about criminal records or often eviction records are gathered in the same way, are from other consumer reporting agencies and they call them vendors. Usually LexisNexis is going to be the source of many tenant screening, landlord-tenant records and criminal records, because CRAs find it much easier to just pay LexisNexis for their data, and then LexisNexis goes and gets the information directly from courthouses, sometimes by court runners, sometimes by buying big databases. But the data source problem becomes really, really important, as Jim was saying in the expungement case, because LexisNexis doesn't actually update it that frequently. I think the term in the contract usually is however often is commercially reasonable, and which is business language for never or very infrequently. And so very, very often you see updates to criminal records, particularly including expungements, not being picked up. The other problem that we see with vendors is the initial or some initial steps associated with a criminal case being picked up, or a tenant screening case being picked up, and the disposition never gets picked up. So even, like arrest records that it never shows that they were dismissed, charges that it doesn't show that they were dismissed. Or we'll show you an example of someone whose case was held for court and, 4 or 5 years later, still being reported on background checks as held for court, even though he was acquitted 2 years later, not even 2 years later. So, so these vendors can introduce a lot of uncertainty. There has been a push in the last 4 or 5 years to try to get vendors to be disclosed, either on the face of the report or on the disclosure to the consumer, so that people know when there's an intermediary involved that they can go to. So people can say, okay, LexisNexis, what do you have on me? So we'll talk about that as we get more toward addressing problems and making sure that they don't recur. I see the question about sample language. I've got one of those right in here for you. So we'll get there.
Yeah.
Jim, yeah, do you have anything to add on vendor sources?
Yeah, so before we get there, let me just throw in a couple more problems here that you see with the vendors. It's very important to know who the vendor is, because sometimes it's the vendor making the error. Yeah. And your client will be told by the reporting agency that, oh, the court record says this, and the client goes to the portal and gets the record, and that record's accurate, and the landlord tenant report is inaccurate, and the reason is the public record vendor is getting something wrong. And a couple of the errors that we've seen recurrently, one is where they get the grading of the offense wrong, that there will be several charges, some are misdemeanors, some are felonies. The misdemeanors, the public record vendor mischaracterizes the misdemeanor as a felony, which, as everyone knows, is a significantly different record than a misdemeanor. And the other one that we see a lot of is when the public record vendor gets the wrong person. So when the consumer reporting agency reports out a particular criminal record, it's somebody else's record because they don't use specific enough matching criteria. So those are two errors we see regularly, which is why it's important to know, where does this error reside? Is it the reporting agency that's doing it wrong? Is it the vendor to the reporting agency? Is there something at the court that's wrong? And that's why the FCRA, at least in the way we have argued it over the years, requires the disclosure of the vendor, even though the industry generally says that they don't have to disclose that information. It's always been our push, and still is, that vendors have to be disclosed because they're furnishers of the information. So let's go to the next slide.
Yeah.
All right, well, I think these are the three provisions that you are going to see most often and use most often on behalf of your clients. The first one is the accuracy provision. CRAs have to have reasonable procedures to assure maximum possible accuracy. It's a very high standard. It doesn't mean get it wrong 50% of the time or 75% of the time. Maximum possible accuracy. So a report that's sold with an error on it, where they're mixing somebody up with the wrong person, or it's a summary offense, you've seen that reported as a misdemeanor, or a misdemeanor being reported as a felony, those are accuracy claims. As we indicated, a few minutes ago, the consumer also has a right to get disclosure, and often the CRAs don't disclose who the vendor is or the data sources. And finally, the investigation provision, that's probably where the bulk of FCRA individual cases reside, is the failure to investigate an inaccuracy. And again, we recall that all of these are subject to fee shifting, and all of these are free, and they should all be pretty simple for you to help your client achieve.
So those are the three big ones that you're going to see in pretty much any FCRA case. But as Jim said, there are some special protections in the employment screening realm of things. So the next slide shows the same three, and then the additional protections that are available in employment screening, which is that people who are the subject of an employment screening, a report that is for the purposes of employment, evaluation of eligibility for employment, are entitled to notice and a copy of the report before the user of the report takes adverse action. And those provisions are under section BB of 1681. But essentially what we call it the pre-adverse action requirement. So ideally what is supposed to happen is the person who's the subject of the report is supposed to get a copy and along with a letter that says, we are considering taking adverse action against you. You have a certain amount of time to tell us if anything on this report is inaccurate. Obviously, in practice, it does not happen like that very, very frequently. You're going to get a lot of situations where people are called into the, the boss's office and sent home immediately, and on the basis of a background report that they might not even get to see a copy of. And so, in our view, those are pretty obvious violations. Now, you're going to have to determine whether the, your client is willing to press a lawsuit against an employer that they may still want to work for. But there are a lot of violations in this area, especially with smaller employers.
Well, can I just jump in here for a second?
Yeah.
So the way I see the BB3 provision is it's basically the accuracy provision for an employer. Although the employer itself is not a CRA, is not required to investigate disputes, the way this provision has been interpreted is that the employer, prior to taking any adverse action, has to give the consumer at least 5 business days before taking any adverse action after providing the consumer with the report. And court decisions and the FTC has held that what this provision means is, within that time period, the consumer has a right to dispute the accuracy of anything on the report with the employer. And I think we all probably know that this just goes against the grain of what employers want to do, especially in a tight job market where they just, they get an application, they see a criminal record, they just throw it back, move on to the next candidate. Can't do that. They have to provide 5 business days after providing the report so the consumer can dispute. And so we have a bunch of cases that are against employers just for that failure.
So is this applicable to a future employer of somebody who's still applying for a job? Yes. So this is prospective employers as well. It actually applies to any person who's using the report for I can't remember the exact terminology off the top of my head, but yes, it's specifically designed for the pre-employment context. And somebody asked about whether this, you're entitled to a copy of the report in the tenant screening context, a copy of the report on which the landlord relies. No. Now, many tenant screeners have sort of just adopted this procedure while they'll push out a copy of the report. RealPage is the big one that's adopted that practice. And it's sort of a double-edged sword, right? In some ways it's good because then the person doesn't have to do anything specific to have a copy of the report. On the other hand, it really is a practice that appears to undermine people's rights to get everything because what they're pushing out does not actually fully reflect what is being used. It often doesn't include scoring and it may not include some of the source data. So it's a little bit tricky outside of the employment context because you may not get exactly what the employer saw. Jim, do you know the answer about whether there are any changes to the pre-adverse action requirement because of COVID? I'm not aware of any.
No, I mean, certainly nothing is passed. You can't get anything past Congress today anyway, but yeah, there have been no changes there. There were some changes as a result of COVID for forbearance and loan modifications, whereby if a consumer was able to get a COVID loan modification, then during that period, the CRA could not report that consumer as being late for failing to make the scheduled payment under the contract, but not for that provision.
Yeah. All right. So now that we've kind of talked about the basic structure and some of the protections, we want to go through some of the steps, the kind of basic steps of evaluating whether you have an FCRA claim and what you might want to do about it. So the next slide, the first step that we've already covered a little bit is make sure you have a copy of the report. Now, what you want a copy of may vary, and what you're entitled to may vary. Hopefully in the employment context, you've already gotten it. Whether it was timely or not is a different question. But you wanna make sure you have the full copy, as Jim said. Sometimes you get only one page of it, but there can be really important information on multiple pages. A couple of the handouts are full copies of the reports that we excerpt that you'll see in future slides. So it may just be valuable to look through the entire report and become familiar with the structure. They're all a little bit different, but often they start with the header data. What is the personal identifying information that was supplied by either the consumer, the individual consumer, or by the employer that was used to do the matching? And that can be really valuable because then you can see sometimes really objective mismatches on the face of the report, which you can really prove an even worse violation. But sometimes you have to ask for a copy of it. Maybe you want to ask for a copy from the landlord. Maybe you want to, or from the employer. Sometimes they'll hand it over and sometimes they won't. Or maybe you want to go directly to the CRA. This is where that file versus report issue comes in. Sometimes you want a copy of exactly what the landlord saw. And so you may want to use specific language that says, please give me the report that you sold to this landlord on this date or to this employer on this date. But you may want to say, give me everything that you have about me, which will give you a broader picture. Some CRAs will include historical reports along with that. Some will only give you a snapshot of what's in the file on the day of the request. So it's useful to think about what exactly you're looking for. Someone asked about an example, and this is literally, I pulled this from a file, and it's helpful to include matching identifiers. Some CRAs require like a copy of a piece of mail or a copy of a driver's license, and that can be really helpful to make sure that they're giving you your client's file and not somebody else's. Anything else about getting a copy of the report, Jim?
No, I think that's probably step number one and probably the most important step.
Somebody asked if you can get both the report sold to the landlord or employer and everything in the file about them. Not usually in the same request. And it depends on the practice of the CRA. So in some ways it might be valuable to do two separate requests. And this is a place where it may be, especially if you have a relatively cooperative landlord or like a user that's relatively cooperative, go to the user for what they had, and then go to the CRA for the full file.
Yeah, and to be clear, unfortunately, the FCRA, like most statutes, has certain gaps. And one of the gaps is that a consumer can't require the user to give him or her a copy of the report. You can get you can force the CRA to give you file disclosure. But if you ask the landlord wants to be stubborn, they're not required to give you a copy of the report. They're required to give the consumer a notice of adverse action, which identifies the reporting agency and the toll-free number and the contact information. But technically, there's no legal requirement for the user to provide a copy of the report that it received.
All right, so let's go to the next slide on identifying. So once you have the report, you want to look at it with your client to go try and figure out what's the problem that your particular client is having. And there's sort of a variety of them that we've covered a little bit, but these are some of the most common accuracy problems. So it's just completely wrong. It doesn't belong to them at all. Which usually is going to result from inadequate matching procedures by the CRA, where we often see matching based on aliases or only requiring the first 3 letters to match. So I'm James and Jared. I should have some better examples off the top of my head, but the first 3-letter matching can be really problematic, or similar sounding. We had a case where it was both of those things. It was alias matching and sounds similar. And for some reason, they thought that Tina, what was it? It was Diane and Tina. They said that sounds, they were using an algorithm that said those names sounded similar. So those are really common.
And Hall and Healy, we've had that.
Yep. Duplication, where the same record appears multiple times. Often they'll be doing like a database search and allegedly sending somebody to the courthouse, and the same record will appear multiple times, which makes it look like somebody has a worse record than they have. We mentioned expunged records, inaccurate for obvious reasons. Inadequate context is going to be a situation where maybe the offense isn't described correctly, or where it's missing the grade of the offense, which should make something look much worse than it is. Similar is description or case level, misdemeanors versus summary offenses. And there's places where it's really obvious on the face. We've done some of these with CLS, where you can tell from the case number in the Pennsylvania system whether something is a summary offense or a misdemeanor, and they just get it wrong because they aren't careful enough. Failure to update, we talked about, showing charges but not dispositions. In addition to the accuracy, the general accuracy provision, there is an aging off provision under a separate section of the statute that says non-conviction records older than 7 years can't be on the report. So that may come in, but it only applies to non-convictions. So any other common problems?
I mean, we've litigated each of these multiple times against most of the background screeners. That's how prevalent they are.
Yeah. So the next slide is going to give you an example. This is taken from the Wilson report. And so this is a situation where her brother has another lesson. Give your kids different names. So Rashawn Lynn Wilson is her twin brother's name is Rashawn Lee Wilson. And he unfortunately had a lot of interactions with the law that kept appearing. I mean, she had this problem for multiple different background screeners when she's trying to get work, and her brother's records keep showing up because they have the same date of birth. But the other problem that she was having is that she was losing out on the opportunities immediately. She's being taken out of contention. You can see on the upper right, we highlighted decisional. This is another place where you have this problem of employers kind of farming out the decision-making process to the CRA. They give them the criteria and they say, score this for us. And decisional functionally means you're out of the running until you prove otherwise, which can have some serious problems for people. So this would be an example of a situation where you're going to need to talk to your client because although yeah, you can see that there's a difference in the name spelling by one letter, Rashawn versus Rashana, and the L versus Lynn. So that gives you some indicator of the type of inaccuracy, but this is a place where it's going to be helpful to have your client tell you.
And just Lauren, if you stop for 1 second, it sounds obvious, but it's very important that you read these reports closely, because sometimes, as you see in the upper right-hand corner, score decisional, most of the CRAs have changed their terminology now to sound innocuous, but in the industry, decisional means no, this person's got a problem, and it's a disqualifying criminal record. And so they say it's decisional because we had some litigation against LexisNexis about 10 years ago in a case called Good versus LexisNexis, where we were able to persuade the Eastern District of Pennsylvania to find that when the CRA does the scoring itself, it becomes a user of the report and has to then provide notice of adverse action and a copy of the report because it's being the user of its own data. And the scoring used to be like denied or ineligible. And now they've learned that that sounds harsh and it sounds defamatory, which it is. And now they've used these innocuous terms like decisional or C for review, requires review. And then when we've gotten the matrix and discovery, that means no way. So you just want to read these reports very, very carefully because they convey a lot of information and it's not always intuitive.
Yeah. So the next slide is another example. So this would be an example of the failure to update. This is the one I was talking about where his case was held for court. And this is a function, this is actually just a function of how the Pennsylvania court system works. And it was transferred to a different court and got a different case number. And so the CRA was not picking up the update and connecting the two. And so this poor guy who, you know, pled not guilty and goes to trial and gets acquitted, keeps having this, you know, rape conviction or rape charge for like reported when he thinks he's really gotten beyond it. And obviously this is the kind of thing that they need to be picking up. So, but again, this is the kind of thing that your client is going to need to be there and tell you what actually happened. So the next slide, sorry, Jim, did you want to?
Yeah, I was going to say failure to update is a huge source of errors and a huge source of litigation. In the civil public records, we've been co-counsel to 4 national class actions, one against each of the big 3 and most recently against LexisNexis, because the interval of picking up the updates has been 6 months or a year since the change in a status. So I don't expect that problem to go away, even though through these lawsuits and hopefully through some of the pressure from the FTC and the CFPB, the CRAs are increasing their update time periods, but some of these courts are not online, and they're just sloppy and they want to do it in an automated fashion, and they want to sell all the data they can without having to do the work. So I don't expect failure update cases to go away anytime soon.
Yeah. So next slide is about addressing the problem. Once you figured out what the problem is by reviewing the report with your client, what's the best first step? When you're talking about a criminal record or public record of any kind, the best next step is going to be to get the actual public record. Maybe your client has it already. Maybe it's available on the internet. Maybe you have to write to the courthouse and write them a nice letter. Maybe sometimes they charge you for copying, but getting the underlying record is going to be really helpful, because the next step is disputing, and you want to be able to have the best proof you can get. And if you are going to go to litigation, it can give you a really good argument that the CRA had everything they needed if only they would consult the public record. Because oftentimes the vendors do not pull everything that's available on the face of the public record. So this image that you're seeing is the public record, or a portion of the public record that relates to the report that you saw in the previous slide, that shows all the dispositions and the disposition date. But again, for a mixed file or some other misattribution issue, it'll show, there may be a full social security number on some of these, or a partial social security number, or a full date of birth, when only the year of birth is available through whatever source the CRA went to. So getting the underlying record, for particularly in criminal records, is going to be really important. Or you're going to get something that says there is no record, some sort of, I think the Pennsylvania State Police will give you a certification that there is no record, which is helpful in the expungement situation. Anything on records searches, Jim?
Not really. I mean, they're very specific to each jurisdiction. We're in Pennsylvania, and the AOPC is really a leader across the country, as probably many, if not most of you know, in terms of providing the most organized and updated version of records and the searchability, and also having what's called a life cycle file, which many of you probably know about as well, where users and other CRAs can purchase a life cycle file, which will automatically give them updates from the AOPC. Not every state has that. It's interesting to me that Pennsylvania kind of leads the pack on that, but we've deposed the AOPC, and frankly, I was pretty impressed by how far ahead of the game they were.
Yep, they've been really a game changer for Pennsylvania records. Okay, so the next slide just shows you a couple of examples of a dispute. That's going to be your next step. And it may be that this is the best thing that you can really do to help your client is help them make a really good dispute to get the record removed. And so some of you may recognize Sharon does the best disputes out there. This is a dispute that Sharon did in connection with one of our clients that unfortunately we did ultimately have to litigate for, but she did an extremely thorough, excellent dispute. On the left-hand side, you see a dispute that an individual did themselves. Neither of these was successful, so I'm not guaranteeing that if you do a beautiful, perfect dispute, it will resolve the problem, but it often does. Especially if you have some of these underlying records, you're very clear about the specific nature of the problem. So for example, you say the grade of the offense is inaccurate, and then you circle the correct grade in the supporting documentation. Now, the obligation on the consumer reporting agency is to conduct a reasonable reinvestigation upon notice that something is inaccurate. So the one on the left is a perfectly good dispute to trigger that responsibility, but how effective their reinvestigation is going to vary, and it can be very helpful to be very specific. And then the other thing it does is really set you up in a really good place if you do need to litigate, because you've put this company on notice of exactly the nature of the problem. And so if they don't fix it, your claim gets a lot better.
Yeah, Lauren, let me just share one caution here.
Sure.
That I don't think is insignificant, and that is, as Lauren just said, the dispute serves two purposes. Number one, you might be able to get it corrected without litigation, but if you don't, it raises the value of the claim. However, there is some case law, especially from the Eastern District of Pennsylvania in a case called Klotz versus TransUnion, where courts have held that a dispute letter that comes from a lawyer, such as you, it doesn't trigger the reinvestigation obligation, so that if you were to sue on behalf of that client, you couldn't recover on an I violation or the reinvestigation violation, because the dispute was not made directly by the consumer. So I agree with Lauren. Sharon's disputes have always been incredible. But in thinking about how that case plays out, seeing the problems that we've faced with that case, I would write the dispute letter and just have the client sign it and send it in the client's name. Then you don't have any problem with the directly concerned.
Yeah, I agree with that. There's sort of discussion in the FCRA community about who should write and send the dispute, and we've seen it both ways, and sometimes it's not a problem, but yeah, particularly here in Pennsylvania, it's probably best practice to put it in the client's name. So next slide is, do we know what the dispute on the right, why the dispute on the right was unsuccessful? It was handled poorly by the CRA. Which happens a lot.
Which is systemic, because
it's systemic, and it's not. They try to tell you it was, individual error. The individual person just messed up. These are people who are paid, barely over minimum wage and have quotas about how many of these disputes they need to process at once. And they are often given very limited tools. And they have to code them, and they're given very limited training. So there are really strong arguments about why it's not. It's systemic. It's not individual. It's almost never individual operator error. So this is another place that I think legal aid attorneys can get a lot of assistance on the ground for people who've had problems with criminal record recurrence, either because they have a common name, they have this situation where they unfortunately share a name with somebody, like our client Rashana Wilson, or where they've had an expungement. Being proactive to try to prevent it from happening again can, I think, be really game-changing for people. So often, if you're going to have a mix in one background screener, you're going to have it with others, because a lot of these practices are really similar. So you may want to, if they have a problem with Checker, you may want to try to find out what First Advantage is reporting about them, Or if they have a problem on RentGrow, you may want to find out what RealPage or AppFolio or TransUnion Rental Screening Solutions, what they're reporting. So getting those disclosures and making disputes before the report even gets sold, because a lot of the time people don't have any notice. Like they sign the rental application, but they don't know who the company, the CRA, is going to be. In fact, they may sign the consent and it doesn't specify. So helping people prevent the problem from recurring by making those disputes even before the application happens can be really helpful. And then this is going back to the vendor issue. Like if you have a criminal record or a landlord-tenant issue, get your disclosure, have your client get their disclosure from LexisNexis. Do the broadest possible request, everything you have on me. Hopefully Lexis has, like, you can get like a 40-page disclosure from Lexis sometimes. And then hopefully you can prevent it from spreading if you can get it corrected at the vendor source.
So
doesn't always, oh, sorry, Jim, anything else on that one?
Yeah, I was just going to offer some practice pointers that a lot of FCRA claims require a predicate act by the consumer, such as in order to trigger the file disclosure, they have to request their file. In order to have the CRA conduct an investigation or reinvestigation, they have to make a dispute directly. And so what I would do, just in terms of making your job and your life easier, is I would have, and we can help you out with this, or if you just want to ask us, I would have a standard like file request letter ready for your client. Dear blank, pursuant to FCRA section 1681G, I hereby request my file and the sources. There's certain words that are important to be period. And then the investigation letter that's drafted, that's kind of like a form letter that outlines exactly what the error is. The more information that you provide to the CRA, the more you put them on notice, the better the claim, the more likely also that the error will be removed. Also, you're probably going to want to have all of the different CRAs, either by way of a mouse click or otherwise, all the contact information for the RentGrows, TERS, First Advantages of the world, Sterlings, all of them in one spot. And if you want to, you can just come to our website. We have a page that just has all the specialty consumer reporting agencies at consumerlawfirm.com. We have a page just for that. You could just copy that link and paste it on your own site, or just use it as a favorite, and that enables you to see all the different CRAs out there who are players in these different industries. So it's just a few basic steps that will make your life easier and make your ability to achieve, get meaningful relief from your client a little, with a higher likelihood.
Yeah. All right. So none of this works. Next slide. Time to bring a lawsuit. So how do you know when it's time to bring a lawsuit, as opposed to taking kind of pre-lawsuit steps to help your client? And the biggest one is going to be if they don't fix the problem after you dispute. There are some types of inaccuracies that you probably don't even need the dispute for, but I think in general, especially in the legal aid context, you're best off is to dispute first. And if they don't correct it after a dispute, then consider bringing a lawsuit. Sort of similar in terms of getting a file or report copy. I would make sure that you're doing a couple of requests before you try to bring some sort of disclosure violation. Also, I'll just, since Ramirez came up, that case just recently went to the Supreme Court, and the Supreme Court said some pretty troubling things about whether you can even go to court at all about a disclosure violation. So you have to, I would say, only bring a disclosure violation case if you have a very good story about a not getting the file or report hurt your clients, had a really concrete effect on your client going forward. The other question is, when do you think you might have a class action? And obviously just come talk to us if you think that there's an issue, but I'll just say, like, same fact pattern repeated with the same CRA is gonna give you a hint that that's something that needs to be addressed or could be addressed systemically. Like already in the, I feel like already in the questions, I've seen a couple that I was like, ooh, that could be a good class action. Somebody, said something about mugshots. I'm super interested in sort of the information that's being reported on, especially on the maybe even the people that aren't the major players. You guys are actually the people who are on the ground and see these and know when you're seeing the same fact pattern over and over. And we always want to hear about that. And if there's something that we can be addressing in a broad way through a class action. So, Jim, any other thoughts on when it's time to sue or when to think about a class action?
No, I think we've, if you have any questions, reach out. I think we've identified the repeat fact patterns that are problematic, the common liability scenarios that give rise to cases. And, you know, for some of these, just listen to your gut. If this doesn't seem right, someone's stuff for because of somebody else's information, or they went out and they got you or another legal aid lawyer to get something expunged, and then that information is still being recorded, all of those feel like harms, and they are. They're probably FCRA violation. So, you know, I think we've highlighted the major ones. There are always little idiosyncrasies and nuances to those, but we tend to know what the industry's real problems are, and we've identified a lot of them.
So I don't know, we're kind of at the end of our time. I don't want to take up a ton of people's time, but let's see. Jim, are you familiar with Reputation Defender or other services like that? And do you have any thoughts on what role they might have in the FCRA space?
Yeah, so we don't have any cases that I know right now against Reputation Defender, but Reputation Defender is one of a number of reputation websites. The one we have a lot of litigation against is a company called mylife.com. And they don't function as a typical CRA because they tend to just live online, but MyLife sells a very offensive product. And if anybody has any extra time today and you want to get offended and pissed off, what I would tell you to do is go to mylife.com and search for your name. And then what they're going to do is they're going to tell you they have a reputation score on you from 1 to 5. But then in order for you to obtain that reputation score, they're going to make you sign an arbitration clause, and they're going to make you pay. And so by the time you get it, you've now opted out of the class action and you're forced into arbitration. And then it's usually full of all types of inaccurate information. And that's not just for your clients, that's for people in general. Reputation Defender sells something similar. What they're doing is they're under the guise of, I'm going to help you with clean up your reputation. I'm going to tell you that I'm selling false information about you. So come to me and I'll charge you for cleaning up information that I should have accurate in the first place and shouldn't be selling in the first place. It's kind of a form of extortion and holding you hostage. I would be very interested in talking about any claims against those type of companies, but there are some legal challenges there. But that exists, and they're awful products and awful companies. What else do we have? Any other questions or?
Let me see. I think that's everything. Oh, yeah, I think that's everything. Thank you, everybody, for coming to this. And the next slide has, and both the first slide and the last slide have our email addresses. Email us, and we will absolutely love to help you with your FCRA questions.
Well, thank you so much, Lauren and Jim, for that very, very helpful training here. We will be following up with you all and provide those materials again. We're going to also try to see if we can rustle up together some sample letters that we can send you guys so you have that language in an email that you can use. So be on the lookout for that today or tomorrow. And thank you all for coming.
Thank you.